On October 13, 1867, the Chief Justice of the United States read a name out loud in a federal courtroom: Elizabeth Turner. She was a child, a minor. The record does not give her age. What it gives us is this: she had already been free for 2 years. The 13th Amendment had been ratified in December of 1865. Slavery, in the eyes of the law, was finished. The war was over. The Confederacy had surrendered. Congress had passed the Civil Rights Act of 1866, which stated plainly that all persons born in the United States were citizens, equal before the law. And yet, on the date that petition was filed in 1867, Elizabeth Turner was still working inside the household of the man who had once owned her. Not by choice. His name was Philemon T. Hambleton. He was a resident of Talbot County, Maryland. He had filed a legal document, a contract, reviewed and approved by a county court. The document said, in the formal language of the law, that Elizabeth Turner was his apprentice, that she was placed in his care for training, for her own benefit. It was not an apprenticeship. A man named Charles Henry Minoky filed a habeas corpus petition on her behalf. He was not a lawyer. He was a friend of her mother. That petition reached the United States Circuit Court. It reached Salmon P. Chase. And on October 13, 1867, Chase ruled. What the Talbot County Court had approved, what it had called legal, was not legal. What it was and how it had been done is what this record shows. By the time the ruling came down, over 100 children in Maryland were still being held the same way. Elizabeth Turner was not the only one. Maryland in 1865 was not the Deep South, but it was still a slaveholding state, and the men who had held that power were not prepared to release it simply because a constitutional amendment told them to. When emancipation came, they turned to the courts. Maryland, like other border and southern states, had statutes on the books called apprenticeship laws. On paper, these laws existed to protect orphaned or destitute children, placing them with employers who would house and train them until adulthood. It was a system that sounded reasonable. In practice, it was used for a single purpose: to take black children away from their freed parents and return them to the households that had previously enslaved them. The process was not complicated. A former enslaver went to the county orphans court, a local probate institution staffed by local appointees. He filed a petition. He stated that the child's parents were unfit, unemployed, unable to provide a stable home. The court reviewed the petition. The court, in most cases, approved it. The child was assigned. The parent received no notice, had no legal standing to challenge the ruling. The clerks recorded what they were told. The paperwork was filed correctly. No one questioned the paperwork. Talbot County, Maryland, 1865. Philemon T. Hambleton had been an enslaver. After the war, he was a private citizen. Among the people he had previously enslaved were a woman and her daughter. After emancipation, the woman took her daughter and left his property. Hambleton went to the Talbot County Orphans Court. He did not go as a criminal. He went as a petitioner, within his legal rights, using a process that existed precisely for situations like this one. He filed for apprenticeship of the child. He stated she had no suitable guardian. The court did not contact her mother. The court did not investigate the claim. The paperwork moved through the system the way paperwork moves when no one is watching it. The court approved it. The contract was signed. Elizabeth Turner was returned to his household. Her mother had no paper, no lawyer, no standing in that court. The apprenticeship contract that Hambleton filed with the Talbot County Orphans Court was specific in its terms. Elizabeth Turner would remain in his service until she reached adulthood. He would provide housing, food, clothing, and what the contract called moral instruction. She would work. The contract read like a labor agreement. It used a language of care and training. What it did not say, what no contract of this kind ever stated, was that the child named in it had been born into bondage in that same house, that her mother had been enslaved there for years, that the household receiving her was the same household that had held her family as property under the laws that had just been abolished. The Talbot County Orphans Court did not ask those questions. It reviewed the paperwork. It found the paperwork in order. It approved the contract. This was 1865. The 13th Amendment had been law for months. Elizabeth's mother could not challenge the ruling. She had no legal counsel. The Freedmen's Bureau had established offices in Maryland, but their resources were stretched thin across hundreds of counties and thousands of cases. One apprenticeship contract in Talbot County was easy to overlook. The system had been designed, in part, to be overlooked. Hambleton was not an outlier. Across Maryland alone, former enslavers were filing the same type of petition in the same type of court and receiving the same type of approval. The courts were local. The judges were local. The interests were local. The 13th Amendment was a federal document. At the county level, in the Orphans' Courts of Maryland in 1865, it had not yet arrived. For 2 years, Elizabeth Turner remained in Hambleton's household. 2 years after emancipation, 2 years after the constitutional amendment that was supposed to end this. The record does not tell us what those 2 years looked like inside that house. It tells us only that on April 22, 1867, someone decided to act. His name was Charles Henry Minoky. He was a friend of Elizabeth's mother, and he knew what a habeas corpus petition was. A habeas corpus petition is a specific legal instrument. Translated from Latin, it means produce the body. In legal terms, it asks a court a direct question. On what lawful authority are you holding this person? If the authority cannot be demonstrated, the person must be released. Charles Henry Minoky filed that petition on behalf of Elizabeth Turner in 1867. He was not a lawyer. The petition was valid nonetheless. It challenged Hambleton's legal right to hold Elizabeth under the apprenticeship contract. It asked the court to review whether that contract was lawful under current federal law. The case moved to the United States Circuit Court for the District of Maryland. The judge who received it was Salmon P. Chase. Chase was not a minor official. He was the Chief Justice of the United States Supreme Court. In that era, Supreme Court justices also served on the federal circuit courts. They traveled to hear cases in lower federal courts within their assigned regions. On October 13, 1867, Salmon P. Chase sat in a Maryland federal courtroom and opened the file for Elizabeth Turner. He reviewed the Talbot County Orphans Court contract. He reviewed it against two documents that court had not considered. The first was the 13th Amendment, ratified December 1865. It prohibited slavery and involuntary servitude throughout the United States without exception. The second was the Civil Rights Act of 1866, which declared all persons born in the United States to be citizens, entitled to the same legal protections regardless of race. Both documents existed before Hambleton filed his petition. Both existed when the county court approved it. The county court had approved a contract binding a freed black child to her former enslaver after both of those laws were in effect. It had called that contract legal. Hambleton did not retain legal counsel to contest the federal review. He did not mount an aggressive defense. The record does not explain why. By October 13, 1867, the case was before the highest judicial authority that could hear it, and the evidence against Hambleton was the county's own paperwork. Salmon P. Chase's ruling was direct. The apprenticeship contract binding Elizabeth Turner to Philemon T. Hambleton was unconstitutional. It violated the 13th Amendment. It violated the Civil Rights Act of 1866. It was void. Elizabeth Turner was released from Hambleton's household. She was returned to her mother. Her mother's name does not appear in the surviving court summary. The record that freed her daughter does not record her name. She was there. The record simply does not say who she was. That is the kind of gap the archive leaves. Philemon T. Hambleton faced no criminal charge. He was not fined. He was not removed from any public role. He had used a legal system legally within its written rules to hold a child. The consequence the law could give him that day was the only one it gave. He lost. The contract he had filed, the one the county had approved, the one that had returned Elizabeth to his household for 2 years, was struck from the record as unconstitutional. Hambleton did not contest it. He did not appeal it. Historians who have studied this case have noted something else, something the record does not confirm but does not deny, that there may have been a reason Hambleton chose not to have this matter examined any further. The ruling had consequences well beyond Talbot County. In the months following the Turner decision, Freedmen's Bureau agents across Maryland used it as a legal basis to review apprenticeship contracts filed by other former enslavers. More than 90% of black child apprenticeships in the state were overturned. One petition, filed by a man who was not a lawyer, on behalf of a child whose age the record did not preserve, heard by the Chief Justice of the United States. The contract Hambleton filed said Elizabeth Turner was an apprentice. The federal court said something different. On October 13, 1867, she went home.